Welcome to the OISC. Congratulations on becoming registered with the Immigration Services Commissioner. This webinar is designed to offer an overview of your responsibilities to the Commissioner and covers topics that will affect you while you are registered. This will very much be a broad brush approach, with further webinars being developed that will cover some of the topics in more detail. The Commissioner has a general duty to promote good practice by those providing immigration advice or services and, as part of the regulatory function, ensure registered advisors are and remain both fit and competent. This requirement is rigorously applied to both individuals and organisations seeking entry to the scheme and those already within it.
Some of you will be starting work as an immigration advisor with an existing registered organisation, while others will be setting up a new business. The Commissioner's Code of Standards set out which responsibilities are for the business and which are for individual advisors. For those setting up a new business, being aware of the responsibilities of the organisation from the onset will help you set up practices that build compliance into the system. This webinar will help you get started. For those joining an existing organisation, it is important that you are able to identify if it operates in a compliant manner and has processes in place to allow you to operate in such a manner. Again, this webinar will help you to identify important responsibilities that advisors at times get wrong.
Webinar aims. This webinar will offer an overview and guidance on the responsibilities an advisor and organisation has to the Commissioner and to clients. These are 1. To remain fit and competent, 2. To comply with the OISC Code of Standards, 3. To act in the best interest of their clients.
Webinar objectives. This webinar covers 3 principal areas. 1. Records and record keeping. 2. How the OISC assesses ongoing compliance. 3. Working with the OISC.
Chapter 1. Records and record keeping. This chapter covers record keeping, financial records, client care opening and closing letters, and client list. Record keeping. Of registered organisations audited in 2017 to 18, 63% were found to maintain insufficient records. The necessity for good record keeping cannot be overemphasised. Such records are a way of demonstrating an advisor's competence to the Commissioner. Record keeping is vital to ensure that you are clear on what the client is asking you to do. You are protected if the client later suggests you misunderstood them or acted without or against their instructions. You cost the work accurately for the client if ever challenged. You can provide your client with a clear record of actions taken should they need to progress their matter with another advisor or representative in the future. And you comply with a code requiring you to keep adequate records.
An adequate record of all interactions as required by the Commissioner would include everything relevant to a client's case, such as details of instructions taken, advice given, including the merits of any proposed action, action taken and by whom, attendance notes of any meetings or conversations between you, the client, and any relevant third parties must include a record of the discussion. Financial records. Notes should be dated and it should be clear who wrote them.
It is imperative that the note made of the first substantive meeting or conversation between you and the client must include full details of the client's immigration history, the instructions taken, advice given, and action agreed. Case notes should include copies of all relevant correspondence with the client or third parties, such as application forms and supporting evidence. While client records can be held either on paper or within electronic files, Such records must be maintained in an orderly manner, with the progress of each case being clearly recorded.
When considering record keeping, it is useful to think about how such records will be accessed. If a client requests a copy of their case file, will you be able to produce it easily? What will happen if they need their file and you are abroad or unwell? Similarly, if the Commissioner asks you to produce a copy of a particular case file because they have received a complaint, will you be able to locate it quickly? This will be much easier to do if all the documents and correspondence are kept together in one place. In summary, you need to consider both the quality and efficiency of the records you make and how you store them. The codes are not prescriptive on how you do this, but records must be sufficiently detailed and must be accessible to those who need them.
Financial records. Fee-charging organisations are required to keep financial records of transactions with clients. When these financial records are examined during an audit, it must be clear whom each payment relates to. There must be a documentary evidence of you issuing invoices and receipts to each client. If you have a client account, you should use it to hold fees paid in advance until the work has been completed.
Client care opening and closing letters. These are fundamental documents to ensure the client is aware of the work to be done and the work completed. Of organisations audited in 2017-2018, 75% were found in breach of diligence in client care. A good client care letter will be client-specific, taking into account their particular circumstances, will contain a record of their immigration history, details of their instructions to you, details your advice and assessment of the merits of the proposed application, and details the agreed action.
Before undertaking any further work on behalf of the client, you must ensure you receive confirmation from them that they have read the client care letter and agree to the content. This can be done by signing and dating the letter, or by sending confirmation to you by email or other electronic means. While any new or significant changes to existing instructions may not require you to issue a new client care letter, you must confirm these instructions and your advice to the client in writing.
Upon concluding a client's case, it is not sufficient to write to them stating only that you have closed their file and will retain it for 6 years. The closure letter you issue must include confirmation of their immigration status, any dates or restrictions on their leave, a list of the original documents being returned to them, and a financial statement confirming whether your fee has been paid in full or stating the amount still outstanding.
Client list. A client list must be maintained, and it is recommended that you set this up as soon as your OISC registration has been approved and you start being instructed. The information your client list should include is the client's name, a case reference number, a description of the work being undertaken and the level it falls within, as the same person may instruct you on a number of matters, date the file was opened and closed, the name of the advisor dealing with the case, if there is more than one at your organisation. The client list will be used by the OISC during audits. Please note that the OISC has the facility to check your list against the information held by the Home Office.
Chapter 2. How we assess ongoing compliance. This chapter covers premises audits, complaints, complaints redirection scheme, OISC Complaints Scheme, continuing professional development. Premises audits. One way that we can ensure you are complying with the Commissioner's codes of standards and remain both fit and competent is through the premises audit process. This involves your OISC caseworker undertaking a review of your case files, policies and procedures. It is also an opportunity for you to raise any issues you may have. Each year, the OISC selects a number of organisations to audit. If you are a newly registered organisation, it is likely that we will want to audit you after you have been practicing for some months, so that we can see how you are getting on.
You will be contacted to arrange a date on which the audit can be undertaken, and prior to this, you will be asked to provide a client list detailing the cases you have worked on, including the information as detailed in the client list section earlier. On the day of the audit, all case files will need to be made available so that the caseworker who attends can randomly select those they wish to review. All the policies and procedures you submitted with your application for registration, as well as your financial records, should also be available for inspection on the day.
Normally, the caseworker will arrive for the audit around 10 a.m. and we will have an initial discussion with you, after which the majority of the day will be spent on their review of your case files. They may need to speak to you during the day or to other members of staff, but normally you will be able to conduct other work in the office on the day. After the review of your files, policies and procedures, the caseworker will provide you with feedback on their findings. This is your opportunity to discuss any points where there may have been a misunderstanding. After this discussion, the caseworker will let you know if and where improvements can be made and arrange a date for a follow-up audit if required. Following the audit, you will receive a report identifying the issues raised, if any, and action you will need to take to ensure you are fully compliant with the codes of standards.
Complaints. The OISC has two methods of investigating complaints. 1. The OISC Complaints Scheme. 2. Complaints Redirection Scheme. While you hope that all clients will be satisfied with the immigration advice and services they receive from you, there may be occasions when they are not satisfied and wish to complain. On these occasions, you should encourage the client to approach you first, as you may be able to resolve their problem more quickly than the OISC. For newly registered organisations and newly authorised advisors, being notified that a complaint has been made against you can be distressing. It is important to understand that although an allegation has been made against you, it is only an allegation, and the fact that the OISC is looking into it does not mean we believe you have done anything wrong. We are required to consider all complaints made to us. The key issue concerning complaints is to work with us so that the matter can be concluded as soon as possible.
If the OISC decides the complaint should be investigated, a decision will then be made as to whether the complaint should be redirected to you to investigate under your organisation's complaints procedure or passed to an OISC caseworker to investigate. It is the OISC's duty to consider not only the issues the client has raised, but also any other issues which may demonstrate your failure to comply with the codes of standards and which raise issues as to your fitness or competence. Complaints Redirection Scheme. Should the complaint be redirected to you to investigate, the OISC will have oversight and you will be asked to provide a record of your investigation. It is hoped that the redirection process may lead to a speedy resolution to the client's complaint. However, please note that if the Commissioner remains dissatisfied by the way the complaint has been investigated, the complaint may be passed to an OISC caseworker for investigation.
OISC Complaints Scheme. When a complaint is investigated by the OISC, you will be provided with details of the issues raised by the client in a statement of complaint. You will then be given the opportunity to respond to the potential breaches of the Code of Standards. The Commissioner's Complaints Scheme requires you to comply with all reasonable requests during the investigation. At the conclusion of the investigation, a determination will be issued to you and the client. In determining complaints, the Commissioner's standard of proof is the civil standard, being on the balance of probabilities. The complaints scheme is evidence-based, which is another reason you should retain adequate client records, as these will be relied upon during the investigation.
The potential outcomes from having complaints substantiated against you are set out in the Commissioner's Complaints Scheme. The majority of substantiated complaints record a breach of the codes on your record, and you are expected to learn from the issues raised and take steps to ensure compliance in future. In this instance, the OISC may issue recommendations and practice points. A very serious complaint finding could result in your authorization to practice being cancelled.
Continuing Professional Development, CPD. CPD is one way of ensuring that those advisors who the OISC has assessed as being fit and competent remain so. The OISC CPD scheme is principle-based, with a focus on learning outcomes that can be put into practical use when dealing with client cases. The Commissioner requires each advisor to have a CPD training plan and record in place that details their training needs, how these needs will be met, and to keep evidence of training completed. Advisors need to keep up to date with changes to the immigration rules, Home Office policies, and case law, and a suggested way to do this is to join a membership organisation that sends out regular updates. Advisors also need to keep up to date with their OISC obligations, for example, by reading the OISC newsletters and webinars.
Organisations should build in training and study time for their advisors and ensure that systems exist to identify their training needs, such as through performance reviews and appraisals. Completed training should be evaluated to ensure relevance and value, and if it did not meet the training needs, then a different approach should be used next time. Organisations also need to identify the training and development needs of the business itself. These could include IT skills, obligations under the protection of information, skills in maintaining adequate records and accounts, as well as softer skills like communication. The OISC runs a number of workshops during the year to which you will be invited. The subjects covered include complaints, audit and compliance, consumer satisfaction, and professional ethics. As well as being informative, these workshops provide advisors with an opportunity to meet and network with other advisors and OISC caseworkers.
Chapter 3. Working with the OISC. This chapter covers the following subjects: organisation websites, change of circumstances, continued registration, contact with the OISC. Organisation websites. If you have a website for your organisation or are thinking of setting one up, you need to ensure it features your OISC registration number and accurately reflects your organisation and those advisors within it, as it could be your main source of attracting clients. It should contain information that helps a client decide to choose you as their advisor, for example, by showing your fee structure, the type of work that you do, and your experience.
The website should not contain any potentially misleading information, such as suggesting that the organisation comprises a team of authorised advisors if, in fact, it consists of a sole advisor. Statements must not be made about organisations or advisors' success rates, and promotional material must not criticise other organisations or advisors. In addition, where an organisation is newly registered with a small client base, it would be wrong for it to be described as being an established company and a market leader in immigration.
Changes of circumstances. You must notify the Commissioner within 10 days of any changes taking place that may affect your or your organisation's fitness or competence. Changes could include a new advisor joining the organisation, an advisor having an extended period away from the office or leaving, ceasing to provide immigration advice and services, changing address, an advisor or any person owning or running the organisation being subject to bankruptcy proceedings, if any advisor or any person owning or running the organisation is arrested, charged, cautioned or convicted, and if an advisor or any person owning or running the organisation is investigated by the police or the Home Office. Please note, the list is not exhaustive and you should contact your caseworker if you are unsure whether you need to notify the OISC of any change.
Continued registration. A couple of months before your organisation's registration year is due to expire, a letter will be sent inviting you to reapply for continued registration. When making your application, you can include new advisors and raise the registration level of an individual advisor or the organisation itself. You can also register a new legal entity, for example, if you change to a limited partnership from a sole trader. If it is not possible for the OISC to make a decision prior to the expiry of your current registration year, your licence will be extended and you will continue to provide immigration advice and or services at your existing level. While an application to increase the registration level of your organisation or individual advisor or to register a new legal entity can be made at any time, it is worth doing this at the continued registration stage to avoid paying 2 registration fees in 1 year.
Contact with the OISC. In the letter approving your registration, you will have been provided with the contact details of your organisation's compliance caseworker. While this caseworker is responsible for your organisation's overall registration, they may not always deal with straightforward individual advisor applications or continued registration applications. If your organisation consists of a number of advisors, any contact with your caseworker or the OISC as a whole should be via your organisation's primary contact. Information on regulatory matters can be found on the OISC's website and through OISC newsletters.
Before contacting your caseworker, the OISC's website should be the first place to look for information if you are unsure of anything. Useful information can be found here includes codes of standards, guidance on competence, guidance notes, practice notes, webinars and training, how to apply for continued registration, how to increase your level of authorization, how to add a new advisor.
Another source of information is the OISC newsletter that contains articles on a range of regulatory matters. This is generally issued every quarter and is placed on the website together with older newsletters. Webinar outcomes. Now that we have come to the end of this webinar, you should be aware of 1. The requirements the Commissioner places on individual advisors and organisations. 2. Records and record keeping. 3. How the OISC assesses ongoing compliance. And 4. Working with the OISC.
Webinar evaluation. Thank you for taking the time to complete this webinar, and we hope that you found it to be useful and informative.